Thank you for joining us today for a seminar on the fundamentals of estate planning. My name is Mark Patalski, and I'm pleased to serve as your host today. I am PACE's Director of Plan Giving. In that role, I work with many of PACE's alumni and friends who have included PACE in their future estate plans or might have questions about including PACE, either with a will or a trust or a retirement plan, IRA, or a life insurance policy. There are nearly 400 people who have left an estate gift for PACE, and they are recognized in our Edward Mortola Legacy Society. Today's presentation will include some discussion regarding charitable giving as part of an estate plan. So if any of you are interested in learning more about PACE's Edward Mortola Legacy Society, I'm glad to have a follow-up discussion in coming weeks. Before we get started, I have a few housekeeping tips to share. Your microphone was muted upon entry to the meeting, and we ask that you remain muted to avoid any disruptions. If you have questions during the presentation, please enter them in the chat box at the bottom of the screen. Our speaker will address as many questions as she can following the presentation. Also, please note that some questions were submitted before today. So depending on the time that we have and individualized versus general application questions, we might focus on the questions previously submitted. Please also note that we are recording this session and we'll share the link with you by email shortly. And it is now my pleasure to introduce Horace Anderson, who is Dean of the Elizabeth Haub School of Law at Pace University.
Thank you, Mark. Hello, everybody. I'm so pleased that you're all joining us for this estate planning session. It is my immense pleasure to introduce our speaker, Sheila Samuels. Sheila received her JD cum laude at the Pace University School of Law, now the Elizabeth Haub School of Law, in 2002. With over 20 years of legal experience, Sheila has been a dedicated and tireless advocate, working as an assistant district attorney and at a New York City law firm in a practice representing educational institutions with respect to the educational rights and needs of students with disabilities. Sheila then, following that experience, opened her own practice. Before becoming an attorney, Sheila was a foster care caseworker and handled foster care placements and adoptions. She used her background as a caseworker, arbitrator, prosecutor, and special education attorney as the foundation for her practice at the Samuels Law Firm, with offices in Manhattan, Mount Vernon, and Hackensack, New Jersey. Welcome, Sheila.
Thank you so much, Dean Anderson, for that great introduction. Good afternoon, everyone, and welcome to today's presentation. It's my pleasure to have this timely discussion with everyone with respect to planning ahead and creating a comprehensive estate plan. Before we get started, I just would like to cover a housekeeping rule. In particular, a disclaimer that this presentation is for informational purposes only. It is not intended to provide or give any legal or tax advice. And therefore, any information that you do receive here today, I would encourage you to follow up and seek the guidance of a reputable legal advisor or financial advisor. And so today we're going to be really looking at planning ahead and creating a comprehensive estate plan. And I like this quote by Alan Lakine, planning is bringing the future into the present so you can do something about it now. I often will encounter individuals and families who come to me with respect to crisis planning when, their loved ones have already been diagnosed, maybe with Alzheimer's or dementia, or there's been some type of sudden incapacitation due to an accident, whether a car accident, on the job accident, excuse me, and nothing has been done during this individual's life to sufficiently plan for disability or even in some cases death. And, it does surprise me sometimes because you think about our day-to-day lives and so many things that we do plan for, right? We plan for going to college or furthering our education. We plan for purchasing a home. We plan for getting married. We plan for having children or starting a family. But when it comes to something like creating an estate plan, most of the times people really are reluctant to do it. And I understand the reason why people don't like to necessarily think about death or disability. But what I really like to encourage everyone who I encounter, when we talk about planning early and being proactive by creating a comprehensive estate plan, we really should think about it more so from the perspective of we are taking control over what happens to us, not just post life, right? When we pass away. Most people think, okay, I need a will because I need to decide on who's going to get my stuff when I pass away. But as you're going to see today, a few of the documents that make up a comprehensive estate plan actually deal with what happens with you during your lifetime. And so before we get into those estate planning essentials, I just wanted to touch on some of the benefits of planning early. Some of the benefits include you would be able to protect and provide for your family. That family may consist of a spouse and children. Also, you can avoid family conflict. One of the things that I am encountering more and more in my practice, I'm meeting clients who are estranged from various family members for whatever reason. And many of these clients might be the parent. There's a child that they no longer have a relationship with, or there's a blended family. And so one of the clients wants to make sure that their child from a previous marriage gets certain things. Another benefit to planning early would be you can provide for a special needs individual. Maybe you have a child who has a physical or mental disability that limits their capabilities, and they may need government benefits, or maybe they're already on government benefits. By planning early, you are able to create an estate plan that will certainly take into account this child with the special needs and also allow them to remain on government assistance. You can also leave a legacy for a charitable beneficiary, such as Pace University, right? Or any other organization that may be near and dear to your heart. A lot of our clients will often want to include provisions within their estate plan where they are leaving a specific bequest to an educational institution that they had attended, or an organization, as I stated, that's near and dear to their heart. And we'll certainly get into some ways that you can do that. And then also, many of our clients, another thing that we're encountering, is that our clients want to provide for some of their most beloved family members, and that's their pets. And so we have on several occasions created what's called a pet trust within a client's estate planning document, where they actually outline how much money they'd like to leave for this pet, who would they like to care for the pet, and so forth. Another benefit is leaving a lasting legacy of your choice. I emphasize the words your choice because, again, that also talks about this control. You making sure that you have a say in what happens with your estate during your lifetime and who gets to inherit from that estate when you pass away. Also, it can help to reduce or avoid estate taxes, various expenses that come along when you pass away, a delay in administering your estate when you pass away, and also provide for asset protection and asset preservation. And so what exactly is your estate. Many people seem to think, I don't need an estate plan because I don't have anything. Or if you are a single or divorced individual, maybe your misconception is, well, I don't need an estate plan because anything that I have will just go to my children. And so, or some people say, I'm not rich and I don't have an estate plan. We all have something that will consist of our estate, right? And so some examples of items that would make up an estate would include real property, right? If you own property, whether it's an investment property or a primary residence, that real property is part of your estate. If you own an automobile, that automobile is part of your estate. If you own jewelry, if you own clothing, household furnishings, maybe you have an art collection, maybe you collect, various books on a particular topic, all of that makes up your estate. Certainly bank accounts, right? Usually with our financial accounts, our clients will have designated beneficiaries, but if you don't have any designated beneficiaries, those items would potentially come into your estate at the time of your death. So all of these things make up an estate. And so we know that each and every one of us have an estate in some form or fashion, right? It may not be, an ultra high net worth estate. Maybe it's more mid-range, but regardless of the amount, we all need to have an estate plan. And so what are some essentials when we talk about estate planning? And so today we're going to look at the durable power of attorney, the healthcare proxy, an advance directive, otherwise known as a living will, depending on the state where you live. And I should also mention the information that I'm providing today is really specific to New York State. Also a last will and testament, which can also have special needs trust provisions if you have a special needs child or special needs beneficiary that you wish to provide for. And then in certain circumstances, a trust may be appropriate. And we will see that a trust can be revocable or irrevocable. When we talk about trust, there are different types of trust. And so we'll try to get into some of those variations during today's presentation. So let's look at the durable power of attorney. So what is it? The durable power of attorney is a legal document that allows you to name someone who is known as an agent to act on your behalf with respect to financial transactions. We refer to it as durable because this legal document is going to stay in effect even if you end up becoming incapacitated in some form or fashion, whether it's physical or mental incapacitation that's going to limit your ability to manage your day-to-day affairs. And so the durable power of attorney is one of the most important estate planning documents that you can have in your estate planning kit. The reason for that is because control. We're talking about your finances, not just bank accounts, but also retirement accounts, insurance transactions, maybe real estate transactions if you own real estate, tax-related matters, claims and litigation. The person would be able to act on your behalf with respect to any lawsuits. They could also use the power of attorney to commence any lawsuits on your behalf. And, in my practice, in addition to many of those things that I just mentioned, we will often modify and customize the durable power of attorney to make sure that it includes some other provisions so that it can be a flexible document that will hopefully be able to assist our clients as they age. And so it's a very important legal document. The power of attorney can either be a springing power of attorney or an immediate power of attorney. And when I say springing, I'm referring to the fact that this particular type of power of attorney would require that a particular condition be met before your designated agent can act on your behalf. Typically, that condition is going to be that you are incapacitated. And the way that our clients have used it and the way that I've seen it used is that some of our clients, they don't like to release control. And so they will say to me, Ms. Samuels, I don't want the power of attorney that goes into effect immediately, which would be once you sign it, as well as your agent typically can then just begin to act on your behalf with respect to those particular financial matters. And so some of them will say, well, I don't want that. I'm still competent. I'm able to handle my own day-to-day affairs. I'd rather it be a springing power of attorney. And the condition would be that I end up suffering from some type of mental incapacitation, and my doctor is going to have to provide a note to that effect. And, in those instances, if the client is really adamant that that is the type of power of attorney they want, then obviously I have to do that. But what I often counsel the client on is if you're having issues with releasing that type of control and just doing the type of power of attorney that goes into effect immediately, maybe we need to look at who you're naming as your agent. Because I'm a firm believer that if you know that the person who you're naming is someone who you can trust and they have your best interests in mind, it should not be a problem for you to execute the power of attorney that goes into effect immediately. And again, everything is specific to your situation, but that is just what I have seen over my years of practice that makes the most sense. In terms of agents, you can name a primary agent and you can also name a successor agent. And I encourage all of my clients to name a successor agent. Sometimes our clients may say, well, I don't have a second person that I can name. I only have this one person. Maybe they only have one child. Maybe they don't have any children. Maybe they're not married or they're in a long-term relationship. Maybe they're estranged from their siblings and they don't want to name a family member. In that instance, they may name a close friend and they just don't have a backup. The concern with not naming a successor agent is really what happens if something happens to your primary agent and you don't have a successor agent named. We've seen those situations occur. And when that happens and we really need the power of attorney to do some planning or to get some things done on behalf of our clients, unfortunately, a guardianship proceeding has been needed. And with a guardianship proceeding, and I won't get too much into that today for the sake of time, that requires a court proceeding. A petition has to be filed with the court. And depending on which type of guardianship you are commencing, it's going to slow down what needs to be done. So that's going to take up a lot of time, and it's also going to cost a lot more money. And so I encourage everyone who is present today, to make sure that when you are thinking about creating your comprehensive estate plan, you include a durable power of attorney. And as you can see here, the benefits really include, it would allow your agent to talk to other agencies on your behalf. Again, it provides you the ability to choose who will make decisions for you rather than a court. If you are in a situation where your next of kin is really a family member who you do not have the best relationship with, do you really want that person to make decisions for you and have access to your assets? Also, it just really provides peace of mind for everyone involved. I can't begin to tell you, when my clients have completed their estate planning, it's like this sigh of relief that they usually let out. And so I really would encourage everyone to make sure that this is a part of their estate plan. The other document that also impacts what happens to you during your lifetime and is essential is the healthcare proxy. And so, similar to the power of attorney, you get to name an agent who can make medical decisions on your behalf. And so, the key difference here is that the healthcare proxy goes into effect if you are not able to make those decisions yourself. And so, again, I would think that this is something that would be very important to all of us, that we are the ones naming the person who we would want to make medical or healthcare related decisions on our behalf. You wouldn't just want this power in anyone's hands, right? And so, again, it's one of these legal documents that we all need to have. And so some examples of healthcare decisions could include giving consent to have a particular treatment done or a service or procedure to diagnose or treat your condition. You can also, in your healthcare proxy, you can also designate that you want to be an organ donor or tissue donor, and you can even specify the parameters of any organ or tissue donation. And again, the benefits would be control, really being able to have that say over who's going to make that type of decision or decisions on your behalf. And then the other document that deals with what happens with you during your lifetime is a living will or advance directive. I really think it goes hand in hand with the healthcare proxy. And I'll tell you why, because this is a good way to give a roadmap or guidance to your healthcare agent, as well as any attending physicians who may be treating you. And the primary purpose of the living will, it gives you an opportunity to set forth your own wishes with respect to end of life decisions. What happens if you are diagnosed with a terminal illness or condition, and you may be told that you have months or limited time to live? Would you want the doctors to use certain medical interventions to save you? Would you want to use some experimental drug to be able to see if it could cure your condition or prolong your life? Would you take the position that, if you have a procedure and something goes wrong, unfortunately, and now your quality of life has changed, would you want to still, go on? And so by creating the living will, you're really beginning to think about all of that. And again, I think it's a great way to give peace of mind to your family members or or the person who is designated as your healthcare agent, because again, you have set forth clearly your intentions and wishes. And it takes a lot of that stress and pressure off of your loved ones. And so, some of the differences between the living will and healthcare proxy: in the living will, you're not designating a healthcare agent. That's specifically done under your healthcare proxy. And then, as I had stated earlier, the living will is truly used to help with your healthcare proxy making healthcare related decisions on your behalf, depending on the circumstances, right? And then also, it's a great tool to use to guide the healthcare professionals who may be treating you. Now we come to the last will and testament. And the last will and testament deals with what happens to your estate when you pass away. This is the most common way that I find that people decide to leave their estate. Usually, when someone contacts our office, they will, specifically say, I'm interested in having a will done. They may mention having a trust. We always explain all of the various options to prospective clients. And so a will is a written document. It has to be signed in a particular way under the law of whichever state applies to you. And really, it's the most common way that people decide to dispose of their assets upon their death. But a will does a lot more than just disposing of your assets. So a will also allows you to nominate a person who is going to oversee the administration of your estate. That person is called an executor. And that person has a lot of responsibility, right? Because in overseeing the administration of your estate, that person will have to certainly keep an account of all the assets that are in your estate. Remember when we talked about what is your estate? We talked about all of those items in the beginning, right? It could be property, real property. It could be financial accounts. It could be jewelry. It could be clothing, furnishings, all of those things. Automobiles make up your estate. And so one of the jobs of the executor is going to be to take an accounting of what exactly makes up your estate. And then the other responsibility would be to make sure that they handle the payment of any taxes, because when you pass away, there are certainly taxes that may need to be paid. They're going to handle any other expenses that come along with handling your estate, whether it's debts to any creditors. Maybe there's an outstanding mortgage on a property that you own, just, regular expenses, credit card debt, all of that would be examples of expenses. Another thing that you could do with your will, if you have underage children, would be to nominate a guardian who would be able to manage any inheritance that you're going to leave for your children. Or what if you are a single parent? And now the question is, well, who would you want to raise your child or children in the event when you pass away, they are still minors, right? That's a serious consideration that you have to make. And so your will is where you should make sure that you outline that information, not only who you would want to manage any inheritance you leave for them, but also who would you want to take care of them in the event of your untimely passing. And there are so many considerations that go into that. Some of the considerations really should include someone or a family who really have values similar to yours, right? That are going to make sure that they continue to instill those morals and values that you want your children to have. Another thing that you could do with your will, the will determines when and how your beneficiaries will receive the property that you leave for them. And we can also use the will to include special needs trust provisions. And so what do I mean by that? Some of our clients, even with adult age children in their mid-20s or 30s, they do not think that their child will be financially responsible. And so rather than leave an outright inheritance of, 100,000, 200,000, or maybe a home, they will decide that they want to include certain provisions where they actually hold that money in a testamentary trust. They can have the money staggered based on various ages of the beneficiary. And that is a way for them to really have some checks and balances to make sure that the inheritance is not squandered away. We get that a lot where clients say, yes, they're 25 years old, but I still just think that's a lot of money for someone to have. And so we'd rather make sure that they get it in increments. And so we can do that type of planning through a will. Also, we can do special needs trust planning through a will. It would be a testamentary trust, one that's created by your will and goes into effect upon your passing, but nonetheless, we can do that. If you have a child who is already a special needs person, we can include language in your will to deal with that. Or maybe you don't have anyone who's a special needs person right now, but there's always that possibility that someone could become a special needs person and may be that at the time that you pass away. Then we would include contingent language to deal with that situation where they're not going to inherit the money outright or whatever the bequest is. Instead, we're going to hold that into this testamentary special needs trust, and we're going to name a trustee who is going to oversee the management of that asset for the benefit of that special needs person. And then also through the will, we can determine how debts and expenses of the estate will be paid. You can also outline the disposition of your remains, right? Which may be very important to you. Do you want to be buried? Do you want to be cremated? Do you want something to be done with your ashes upon cremation? We have clients that get really specific about all of these things. Why? Because this is very important to them and they recognize that. I've had clients put in, I want to be buried in this yellow dress or this navy suit. I want such and such songs sang at the service. You can also include language in terms of payment of any memorial services should come out of your estate. And so all of that is really important. And another reason why a comprehensive estate plan should be created. One of the things that I want to touch on when we talk about using a last will and testament as a way to dispose of your estate, nothing in the will really takes effect until the will has been probated, right? And so in New York State, it requires a petition be completed. And with that petition, you also have to submit the original last will and testament, as well as the death certificate and some other documents to the surrogate's court in the county where the decedent passed away. And so once that is done, you then have to also pay a filing fee. And the filing fee is really going to vary depending on the size of the decedent's estate. You have to then wait. And so for some of our clients, waiting is a problem. They do not want their loved ones to have to wait for the court to review the documents that have been submitted and then provide the nominated executor with the testamentary letters, which is how the executor gets the legal authority to start to act on behalf of the estate. Nothing can be done until this will is probated and the executor receives either preliminary letters or final testamentary letters from the surrogate's court. And so if time is a consideration for you, as well as privacy, because when you do submit a will to surrogate's court for probate purposes, certain aspects of your estate, they do become public. And so if time and privacy and having an efficient administration of your estate is a concern for you, that's where we say to our clients, maybe just having a last will and testament is not going to be sufficient for you. And again, it's not something where one size fits all. It's really going to be, what are your main concerns with respect to your estate plan? I wanted to touch on intestacy because this is what happens when you choose not to have anything. If you pass away and you don't have a trust, you don't have a last will and testament, then you have died intestate. And depending on the types of assets that are in your estate, then your family would need to file for what we call administration of your estate. Depending on the size of the estate, it could be a small estate that would be filed, or it could be a regular administration of the estate that would need to be filed. And that's a very different process. There are a few more hurdles to get over. Sometimes a bond may be required to be posted. And the process is just very lengthy. I will tell you, in the New York City surrogates court, even before COVID, we were always dealing with a backlog of cases. And since COVID, it has only gotten worse. I have some cases, and even some of my colleagues, they've told me they've been waiting for letters for anywhere from 1 to 2 years after filing the petition. And so again, I encourage you to really sit and think about what is important to you with respect to your estate plan, because it can be lengthy, it can be costly, and it will become a public document once it's filed with the court. And so for some of those reasons that I just mentioned with respect to some of the disadvantages to just having a last will and testament, some of our clients will come to us off the bat and say, I want a trust. And I'll say to them, why do you want a trust? Because I listened to something on a financial report and they just said a trust is better. And so again, I like to educate my clients or prospective clients first before just jumping in and creating an estate plan for them, to really get a sense of what are the assets, who are the beneficiaries involved, what are the objectives that we're really trying to achieve. And so a trust can be a really great tool to use in estate planning. What exactly is it? The trust is created by an agreement. And the agreement is between the grantor, who is the person creating the trust, and the trustee, who is the person who is going to oversee the management of the trust assets for the benefit of the beneficiaries of this trust, right? And so, as I stated earlier, a trust can take different variations or forms, right? So a trust can be testamentary. So you heard when we were just talking about the last will and testament, I said that we could create a testamentary trust for a special needs person under your will. That type of trust would go into effect upon your passing. We can also create what's called an inter vivos trust, which is a living trust and one that goes into effect during your lifetime. And again, depending on your particular circumstances and the objectives that you're trying to achieve, maybe a living trust is going to be the right tool for you. When we use the inter vivos trust, we are avoiding probate as well as any ancillary administration, right? So again, if avoiding probate is something that is top of mind on your list of estate planning objectives, then an inter vivos trust is going to be the way to go. Ancillary administration deals with what if you have assets in another state? So if you're a domiciliary of New York State, but you also own property. Usually our clients own property in Florida. Maybe they've inherited some land from family and it's in North Carolina or somewhere in the South. That property needs to be dealt with when you pass away. Unless you've taken steps during your lifetime where maybe you've conveyed the property to someone else during your lifetime to get it out of your estate. But if that property, or or if there may be a joint tenant on that property, right? Because that's another way to deal with real property. You can do a joint tenancy with right of survivorship designation, right? Or maybe it's tenants in common. If it's that situation, you're going to have to deal with an ancillary administration, right? And that means that your estate representative, once you pass away, now has to go to that other jurisdiction and commence a separate proceeding. In order to avoid that, we can use a trust and transfer title of that property to your trust during your lifetime to avoid having to do a separate proceeding. A trust can be either revocable or irrevocable. The trust can also have multiple beneficiaries. And as we had stated already, we can also use the trust to provide for special needs individuals as well as long-term care planning. Long-term care planning comes into focus quite a bit in our practice. We use it a lot with our elderly clients who are now beginning to shift their focus, and maybe they're thinking about, if I become disabled during my senior years, how am I going to pay for long-term care? A lot of people are under the misconception that Medicare will cover the cost of long-term care, and that's just not the case. And so we use certain trusts, specifically a Medicaid Asset Protection Trust, to assist our elderly clients with long-term care planning. So special needs trusts, the one that I'm going to focus on here is the third-party supplemental special needs trust, because this is the one where, if you're really doing proactive planning, will greatly benefit you and the special needs beneficiary. And so the purpose of creating this special needs trust, it would be a standalone trust created during your lifetime, as opposed to doing the testamentary special needs trust that we talked about when we discussed creating your last will and testament. This is a trust that would be created by you for the benefit of maybe a child who you know is a special needs person and they are receiving government benefits such as Medicaid or SSI. Those types of government programs, they have very strict asset and income rules. And so you know that you want your loved one to be able to retain receipt of those benefits. We have to do some planning. And so through the third party special needs trust, you can also make sure that your loved one maintains a certain quality of life. We have worked with many families. They have really been able to give their child a certain quality of life, whether it's vacations, access to quality day programs to help promote certain life skills for the special needs child. You can also use it to provide a framework for care and management of assets. Maybe you want some of the funds in the special needs trust to be used for a care team, such as a care manager. Maybe you want to make sure that the special needs child remains in the community, in their own home, or maybe with another sibling or another loved one or family for as long as reasonably possible. And so you can outline all of that in the special needs trust agreement with respect to them not being institutionalized, or if they are, if there's a particular program or certain characteristics of a program, all of that can really be included in the special needs trust agreement. And it really allows you as parents to express your desires and wishes. The main benefit of using this type of special needs trust and really planning ahead, being proactive, is upon the passing of the special needs beneficiary, the remainder, if there is any, in the trust can go to anyone else that you want. It could go to a surviving child. Maybe it could go to the trustee who may take over in the event you pass away before your special needs child. It could even go to a charity, right? You can basically name any beneficiary you want. If you decide to not do any planning, knowing that you have a special needs child, and now you leave an inheritance to that child through your will that may not have the contingent special needs language or any special needs language in it, what will happen is if your child is on public benefits, a first party special needs trust will need to be created in order for that child to continue on public benefits. And, I've seen situations where, because there are very strict guidelines with respect to creating a first party special needs trust, sometimes it just doesn't work. We're unable to create the first party special needs trust for the special needs beneficiary. And now it really is a matter of, well, do they come off of their benefits, or are we going to let them inherit outright? If you have to have a first party special needs trust created, there will be an automatic payback provision that has to be included. And that means that upon that special needs person's passing, Medicaid has to get back whatever money they had paid out on behalf of that child. So again, hopefully this emphasizes to everyone about the importance of doing the planning. I also wanted to touch on the charitable gifting. Give me 1 second. I just want to make sure I didn't miss anything. We talked about it earlier with charitable gifts, and I wanted to touch on it again because this is also something that I am seeing a lot more of with my clients. Many of my clients, whether they are unmarried, no children, they really want to leave a legacy, and a lasting one at that. And so they'll often come to me and talk about charitable bequests. And so the charitable bequests can really take different forms. The charitable gifting can be done by will, right? We can put in a specific request for an educational institution, for an organization. Maybe you're an animal lover and maybe you want to leave a bequest for the ASPCA or some other animal rights organization. Maybe healthcare and access to healthcare is important to you. And so maybe there's an organization, top of mind. Maybe you had an illness and there was a hospital that you felt really helped you on your road to recovery. And so some of our clients would like to leave money for that. Whatever the case may be, you can certainly do it through a will, and you can certainly do it through a trust. And you can have a general provision where you're just leaving a sum of money to the charitable organization, or in case of a school, what our clients usually do is they'll say, I want to leave X amount of dollars to, let's say, Pace University or University of North Carolina for the purpose of creating a scholarship in my name. Or they may say that if the university has many different schools, I want to leave X amount of money to Pace University specifically to be used for the law school or the business school. You can do that through your will as well as through your trust. Another way that you can accomplish charitable gifting would be to name the charitable organization as a beneficiary of your retirement account. And it doesn't have to be the total amount in your retirement account. It could be a percentage or an amount. I have a client right now, most of her estate has been left to a charitable organization. She's estranged from her son. She has left her son, some money. She's unmarried, and she has left the rest of her estate to 2 charitable organizations, including her retirement account. You can also name the charitable organization as a beneficiary of a life insurance policy, or even as a payable on death beneficiary of a bank account. That's what I mean by POD. You can also do what we call pre-death estate planning, right? You can begin to make these charitable gifts during your lifetime if that's what you choose to do. You can use your required minimum distributions from your IRA if you're at that age where you need to begin to take them to fund a not-for-profit, using the qualified charitable distribution. And for some of our clients, they do this because it's a way for them to actually see the benefits of their giving during their lifetime. I have clients, they give to certain charities on an annual basis, quarterly, monthly. It's really just what is going to be right for your particular situation. And so I want to leave time for any questions we may have, but I do want to just go through the comprehensive estate planning checklist again, right? Everyone should have a durable power of attorney. Everyone should have a healthcare proxy, a living will, a last will and testament, or a trust, if that is what is appropriate for you. I will also note that when we do create trusts, the Intervivals Trust, we always create what's called a pour-over will in conjunction with it, because there are times when our clients do not transfer title of all of the necessary assets to their trust. That's very important when you talk about using a trust as a substitute. You have to make sure that you fund the trust during your lifetime. If that doesn't happen, then your executor will certainly need to take your last will and testament to the surrogates court to have it probated, and then deal with the trust assets after they get those testamentary letters. In closing, who needs an estate plan? Everyone. Every adult needs an estate plan. And I tell my clients, including their children who may be as young as 18 years old, think about the college student who you have, they need an estate plan. When they turn 18, they're an adult, and you're not going to be able to just access their information the way you did when they were minors, right? And so if you have children who are getting ready to go off to school in September, I would really encourage you to sit down with them and have them, at the very least, create a comprehensive, durable power of attorney, as well as a healthcare proxy. And any information that was discussed here today, if you wish to follow up with me, you can reach me certainly by email. My information is here, and we are licensed in New York and New Jersey. And so we really do work with individuals and families of all ages and at all stages of life. Thank you.
That's really great, Sheila. I'm noticing a lot of questions that were submitted previously. And so I'd like to start with one. I know, Sheila, that you mentioned a joint property with right of survivorship. And also somebody asked a question, does a cosigner on a bank account have full access to funds when the other cosigner passes, or does it still have to go through probate?
So that's a good question. When we talk about probate, we would exclude certain assets. And those would be called non-probate assets, right? And so those are going to include bank accounts that have joint account holders, right? That's also going to include bank accounts that will have the payable on death beneficiaries. Any property that's jointly owned, like a house. Joint tenants with right of survivorship means that upon the passing of one of the joint tenants, the remaining tenant will inherit the property. There's no need to go to court to deal with that property if there is a joint tenants with right of survivorship designation on it, right? Also, if you're married and the property is titled husband and wife, right? Tenants by the entirety, automatically by operation of law, that is an asset that would not go through probate. It automatically, by operation of law, goes to the surviving spouse. Life insurance proceeds, right? Typically, when you have a life insurance policy, you have to name designated beneficiaries. As long as you are making sure that your beneficiary designations are up to date on life insurance policies, retirement accounts, any bank accounts that you may own, those assets would not come into a probate proceeding.
Okay, thank you very much for that. Appreciate it. Someone just submitted, I mean, we have other written questions that were submitted previously, but someone just submitted a question in the chat. You outlined that somebody could mention the disposition of remains, but is there a way to outline wishes, especially if those wishes need to be determined quickly, buried in 24 hours or cremated versus buried?
So in New York State, there's also a separate document called the Statutory Disposition of Remains Form. And on that, you would be able to list who you would want to be able to make those decisions and also take control over the remains, not physically take control, but obviously be able to make those decisions.
Thank you. This is just a comment on something you mentioned, Sheila. You said, I was surprised to hear that you said sometimes waiting for letters testamentary can take a year or two. So in those circumstances, when people, if they own real estate, they're paying real estate taxes, they have to wait to get authorized to become the executor, unless they go for some kind of preliminary process, like you mentioned. That was, something that was really very interesting to me. Also, if people have an asset like a house, they'd have to make repairs in that, it's a long, if it takes
Sure.
long,
Sure.
the roof and everything like that. So that's something very definitely concerning, which I was a little surprised to hear. So that's something that people should keep in mind, maybe for a trust versus a
Yes.
testament, a
That
will.
that's what I would say, Mark. And I would tell you that I'm not exaggerating when I talk about the backlog of cases in surrogates court, particularly since the pandemic, and they're still very much dealing with it. And so again, if you know that you have those assets that will require immediate attention and that you are trying to accomplish having an effective and efficient administration of your estate, that's where a trust would really be the most effective way to handle your estate.
Mhm. Okay. There was a question previously submitted. Um, as we prepare for retirement, how can we set up our estate for our heirs while reducing our current tax burden? Do you have any thoughts on that one?
So in terms of any tax related strategies, I wouldn't really be able to make any suggestions at this point without having more specifics. That really requires me to have that person's specific circumstances. But in terms of just overall, if you do have a taxable estate, if you suspect that's what the situation will be, gifting whether
Mhm.
to individuals is always a good way to possibly reduce your tax liability, and gifting also to a charity. But again, I don't want to really get into too many particulars, being that I don't have more information.
Right. I see. Here's one that's interesting too, and I'm sure very common. How to plan a will for an elderly parent who remarried.
Mhm. So we see that situation quite a bit. And we would really need to have a better sense of the circumstances pertaining to that elderly parent who remarried.
Mhm.
What are the assets?
Right.
Are there children outside of the second marriage who the elderly parent wants to provide for? Because it's possible a will would be fine, but it maybe a trust would be even better, especially if long-term care planning is going to be a consideration, especially if asset protection and asset preservation is going to be a consideration. We do assist clients at various income and asset levels with long-term care planning. And so if that was something that was going to be an objective for that individual, then we would likely say, let's look at doing some trust planning, and we can accomplish many different objectives for that client by doing trust planning. Without more specific information, that's too broad of a question for me to really answer.
Understood. Okay. Okay. So we're right at the 12:59 now, it looks like, and I think it's scheduled for 1 o'clock event here, 12 to 1. So I think we can move toward closing. Let's see here. I want to thank you, Sheila, for the presentation and for sharing your time and expertise with all of us. I think it was really amazingly helpful, such an education. So I really appreciate that. And thanks to all of our guests for attending today. And we do look forward to seeing everybody at a future session. And I'll just end with a little reminder that, as Sheila mentioned, sometimes people do want to leave a gift for a nonprofit organization, such as PACE. Sheila, being a good PACE citizen, mentioned the School of Law where she attended PACE. We're lucky to have her as an alum. So I do encourage anyone who's interested in leaving a gift for students at PACE in the future to please contact us. And Michelle, you'll be sending out post-event email, so you can reply to Michelle and she'll forward any information about that to me. Thank you very much, everybody.
Thank you, everyone. Have a good day.